Hi, hello. My name is Helen Robinson, and I'm an attorney for Marshall, Forman, and Schlein. I'm a plaintiff's attorney, and essentially we deal with most of it is employment law, some labor law, some civil rights law, but the bulk of my practice, at least, is employment law. I have kind of a different background in that prior to going to law school, which I did a little later in life as a second career, I worked in corporate America, was in all facets of human resources, from representative, specialist, manager, assistant VP, and then also worked in the business unit. So hopefully I have a perspective that's not only from the plaintiff employment lawyer's perspective, but also what you go through as employers in terms of having all the things you're responsible for, and on top of that, the human resources issues. So of course, the title of the presentation is HR and Law, Workplace Changes Since March 2020. And we know since March 2020 is basically when all of our lives changed, both at work and at home. Of course, the end of March was when everything around us was closed, barbershops, nail salons, that stores, and we are essential workers as attorneys, and probably most of you that are in government positions were also in what it was determined to be essential positions and kept working. So what I want to focus on today is more so the legal changes that have happened, because of course changes in the law also impact your operation, and hopefully there'll be some takeaway for everybody. So the first thing, I'm going to start with the federal case, and then also look a little bit later at Ohio case law. So from a federal standpoint, probably the biggest change is really a landmark case, Bostock, depending on how you pronounce it. I say potato, you say potato, but Bostock versus Clayton County, Georgia. And this was decided by the Supreme Court in the summer of 2020. So it's not really new news, but it's certainly worth talking about because, as I said, it is a landmark case. There was a 6-3 decision by the court. Justice Gorsuch wrote the majority of opinion, Justices Alito and Thomas had a joint dissent, and then Justice Kavanaugh had a separate dissent. So I'm just going to go over some of the highlights. Essentially, this was really 3 cases combined into one, all hit the same issue, and it was that the employer fired the employee because of their transgender status or because of homosexuality, which falls under, in this case, discrimination based on sex. So just a real brief rundown of the 3 cases. The first one, with the namesake here, Clayton County, Georgia, Gerald Bostock was a child welfare worker advocate. He had worked for the county for about 10 years, had no performance issues. In fact, his work and the county's work had been commended. He started participating in a gay recreational softball league. And apparently there was a lot of gossip and comments that got back to the county, and he was fired by Clayton County for conduct unbecoming a county employee. And this happened shortly after he started participating in the softball league. The second case was with Donald Zarda, and it was a company called Altitude Express. He was a skydiving instructor. He had worked there for a few seasons, so he wasn't a new employee. And he mentioned that he was gay, and within days he was fired. And then the third case is an individual. It was a funeral home, and an individual named Amy Stevens, A-I-M-E-E, who was presented as male when she was hired. She was treated for depression for years and was diagnosed with body dysmorphia. And it was recommended that she live her life as a woman. So she wrote a letter to the employer before she was going on vacation, letting them know that, quote, she planned to live and work full time as a woman when she came back from vacation. The funeral home fired her before she left for vacation, telling her, quote, this is not going to work out. She had been there for 7 years. So all of the employers admit that the reason they fired these individuals was based on their sexual orientation or transgender status. All of the plaintiffs sued the companies under Title VII, claiming discrimination based on sex. This was probably somewhat of a surprising finding for some, but essentially the finding of the court is that an employer violates Title VII when it intentionally fires an individual employee based even in part on sex. Doesn't matter if other factors contributed to the decision or if women as a group are treated the same as men as a group. if an employer intentionally treats an employee less favorable, quote, because of homosexual or transgender status, it violates Title VII. I realize there's a lot of different thoughts on this subject. It can be controversial. Some people agree with it. Some people believe the court was being an activist court. But really, what it boils down to is it really doesn't matter, because all of those things need to be left outside of the workplace, or you're setting yourself up for a problem. So some of the arguments that the employers presented in terms of why Title VII should not apply. As a start, both parties agreed that in 1964, when the Civil Rights Act was enacted, sex was referring to biological distinctions between male and female. The court said, though, the question isn't just what, quote, sex meant, but what Title VII says about it. Most notably, the statute prohibits employers from taking certain actions because of sex. And so they really parse out the statute. What does because of mean? What does discrimination mean? What does sex mean? And the decision flows from there. So I just want to give you some of the other arguments that the employers made and what the court said about it. So one of the things the employers said in terms of interpreting this part of Title VII is that if you go back to when it was enacted in 1964, there are few people, if any, that would have thought that discrimination in that context was applying to discrimination against homosexual and transgender persons. The court's response to that is legislative history really has no bearing here, quote, where no ambiguity exists about how Title VII's terms applies to the facts, which of course people can disagree about. The other thing the employers said, or the other arguments the employers advanced, was that it should make a difference conversationally how people respond, that any of these people, if they were asked why they were fired, they're probably going to say they were fired because they were gay or they were fired because they were transgender. They're probably not going to say they were fired because of sex, as the statute says. The courts didn't reject, at least the majority didn't accept that argument as well, and said that, quote, conversational conventions do not control Title VII's legal analysis. The analysis is simply whether sex is a but-for cause of the adverse action. The court also mentioned that the employers did not use any historical sources to show that any of the language had changed since 1964. And probably the other argument, there were others, but another noteworthy argument is the employers said, well, hey, we treat people, we're not discriminating against men and women, because if it's a female who's saying she's gay, she gets fired. If it's a male who's saying he's gay, he gets fired. So we're treating people the same. How can it be discrimination? And the court's reaction to that was that the employer's policies have the same consequences for men and women. And it doesn't matter that you treat them the same as a group. They really, the word in the statute is discrimination based on sex because of an individual's sex, focusing on the word individual. So those were just some of the reasons that Gorsuch had in his majority opinion. Of course, there were three people that disagreed with that. Justices Thomas and Alito basically said legislation is what needs to be looked at. The Title VII had not been amended to include sex as referring to, sexual orientation or transgender status. They say discrimination hasn't changed. Sex means what it always meant. And to that, well, they also said the question, quote, but the question in these cases is not whether discrimination because of sexual orientation or gender identity should be outlawed. The question is whether Congress did that in 1964. So really looking at the what they believe was the original intent of the legislation. They go on to say it indisputably did not. The arrogance of this argument is breathtaking. There is not a shred of evidence that any member of Congress interpreted the statutory text that way when Title VII was enacted. So they're looking at what was the meaning of Title VII at the time it was enacted in 1964, and arguing it didn't mean what the court is now saying it means. And then Justice Kavanaugh had a separate dissent, pretty similar, but his was more of a separation of powers, that this is a matter for the legislature, not for the court. His quote was, the question here is whether Title VII should be expanded to prohibit employment discrimination because of sexual orientation. Under the Constitution's separation of power, the responsibility to amend Title VII belongs to Congress and the president in the legislative process, not to this court. And of course, the majority rules with the 6 people, and it's now been enacted as law on the federal level. So the next question is, how does that impact Ohio law, if at all? And that's what the next slide is going to talk about. So in Ohio, the Ohio statute pretty much parallels the federal statute in terms of discrimination under Revised Code 4112, specifically O2. It shall be an unlawful discriminatory practice for an employer to, because of race, color, religion, sex, etc., basically refuse, discharge without just cause, refuse to hire, or otherwise discriminate against the person with their material terms of employment. So the wording is similar, but there has been no interpretation, at least at the time that this Supreme Court case was decided in Ohio, as to what that means. So technically speaking, Ohio law does not prohibit discrimination based on sexual orientation, or at least that's not codified. So the next question would be, in the next slide, would be, then does that apply to Ohio? And our feeling is, there's different versions on this. Of course, as a plaintiff's attorney, our feeling is yes, it does. That traditionally, Ohio courts have followed the same standards that the federal courts follow in terms of analyzing and interpreting the law, the typical McDonnell-Douglas standard. There have been cases brought in Ohio even before the Bostock decision regarding sexual orientation, and the reasoning is that Ohio outlaws discrimination because of sex. And so the argument is that if it's sexual orientation, that you're really still fitting within the parameters because of sex. For instance, if a male likes someone who is male and says that they're gay or identifies as gay, and the employer terminates them, the reason is that if that same male liked females, he would have not been terminated. So then really they're being terminated because of sex. In the past, sometimes that worked, sometimes that argument didn't, but we foresee probably the same thing is going to be applied here as it is in race discrimination, age discrimination, and other types of discrimination cases. The other part of both Title VII and Ohio's law, which isn't talked about as much, is really what we call the opposition clause, where it's not only illegal or unlawful for an employer to discriminate against an individual employee because of, in this case, sex. It's also unlawful for an employee to retaliate against that person because they filed a charge or they participated in an investigation regarding that. It's also unlawful, as you see in Section J, for any person to aid and abet, incite, compel, or assist in this unlawful discriminatory practice. So that's a lot of, the basic federal law and state law. So I just wanted to give one practical example, or one real life example that you can think about. There's a situation where a school, this was a school, employed, of course, teachers, a private school, teachers, not really a principal, but administrators. And there was an employee at the school who was a teacher who confided in to administrators that she was going to soon be undergoing surgery and transitioning from female to male, and that she would like to, from this day forward, be referred to with male pronouns, he, his, him, etc. The employee thought that the owner and director of the school probably would not support this and was really afraid to talk to that person about it. At that time, she talked to other employees and they knew about it, but the owner didn't. So the two administrators did some research, decided to talk to the owner about it to determine what is the best way to handle this type of situation. Initially, they were told, that the school would support the person. They would refer to her with male pronouns and so on. And then at some point, the owner had a change of heart and told the person, you are the gender that you were assigned at birth. We will not be referring to you with male pronouns. You'll be referred to with the same pronouns that you used when you presented yourself for hire, which was that of a female. And also instructed the staff the same way. They should also refer to this person as a female and not a male. The two administrators thought that this was being discriminatory, and they spoke up for the employee and talked to the owner about maybe some things that they could do, that she could do, or he could do to ease this transition. And essentially the owner said, either do what I'm saying or you're going to be fired. And eventually they did not agree to do what in their mind was discrimination against this employee, and they were fired. So the employer's position is they were not fired for anything to do because they were opposing discrimination. They were fired because they disobeyed an order, so to speak, or for insubordination. And of course, the other side is that the people who were fired are charging that they were fired because they opposed a discriminatory practice. What's going to happen? Don't know, because the case has not been decided yet. But I think the takeaway is, even though this is something maybe you have dealt with or that you think you may never have to deal with, at some point you probably will. And it's not just going to be with the particular person who's the subject of this, who is gay or transgender. Most likely it's also going to involve other employees in the workplace as well. So those are the two major takeaways, both the federal law, the landmark case of Bostock, and then the effect on Ohio law. So then I want to talk a little bit about what legislation has changed in terms of employment law. And probably the biggest one is House Bill 352, which is what the next slide covers. So I want to just briefly hit summary of what the legislation is, how it changes procedures, how it changes statute of limitations, what the liability is for employers, and then what employers can use as an affirmative defense. So starting with the summary of the legislation. House Bill 352 has something that has had different iterations of it for years in the legislature. And finally, it was passed and effective in April of 2020. So this was shortly after the pandemic. And essentially what it says is that someone who is alleging discrimination under the statute I talked about, 4112, that they cannot file a lawsuit until they file a charge with the Ohio Civil Rights Commission. Prior to this, someone could go straight to state court and file a charge of discrimination without having to go through the Civil Rights Commission. This law has changed that so that before someone can file a lawsuit with a state court, they first have to go through the Ohio Civil Rights Commission. They have to file a charge and bring a lawsuit within a 2-year period total. Previously, they had to file a charge with the Civil Rights Commission if they were going to do that within 180 days. So the prior statute of limitation was also 6 years. So the statute of limitations has been decreased from 6 years to 2 years. On the flip side, an employee doesn't have to file a charge with the Civil Rights Commission within 180 days. They really have 2 full years. At the end of that process, they, of course, can request a right to sue notice at any time, which is what they're going to need to go to court, much like federal law. But it cannot be issued until 60 days after a charge is filed. So when an employee files a charge of discrimination with the Civil Rights Commission, at that time they can request a right to sue, but it won't be issued until at least after 60 days, where the Civil Rights Commission has had the charge for 60 days. So also, if for some reason the charging party or employee requests the right to sue notice and it's not issued within 45 days after that, they can go ahead and file a lawsuit without it. So the next slide just talks about some of the procedural changes. So one thing is it caps the amount of time that the Civil Rights Commission has to investigate a complaint. I don't know that it was taking longer than 1 year, but statutorily speaking now, they have to complete an investigation within 1 year. And if they're going to file a complaint or lawsuit, do so. If they find there was no probable cause of discrimination, they will automatically issue a right to sue letter to the person filing the discrimination charge, and they can go to court. And really that standard is the 50-50 preponderance of evidence standard. If the Civil Rights Commission believes there was probable cause of discrimination, they will now try to conciliate the charge, and it will work its way through an administrative hearing. However, a person can decide that they don't want to be a party to that hearing as long as they're given notification no more than 30 days prior to the hearing date. They can separate from that and file their own lawsuit. The Civil Rights Commission can continue with its lawsuit. And really what this means, from most of you, I think, are going to be employers or attorneys or human rights or human resources people. And what it essentially means is that instead of a 6-year tail in terms of you getting a charge, maybe someone was terminated and internally they alleged discrimination. Previously, it would have been up to 6 years that they could come back and sue you as an employer. Now, all of that has to happen within 2 years. So after the 2-year mark, they're barred by the statute of limitations of bringing suit. What it may mean in the short run is that HR departments and EEO departments are going to be handling more civil rights complaints, because now anyone who wants to file a lawsuit first has to go through the Civil Rights Commission. I think what it also means is it gives you a little bit of a warning. Instead of just being slapped with a lawsuit alleging discrimination, you will have an opportunity to know about it through the Ohio Civil Rights Commission, and there may be a way to resolve the issue without it ever being a lawsuit. So the next slide I want to talk about, which I really kind of mentioned, statute of limitations, 2 years for both the lawsuit and the civil rights charge. The time that the charge spends being investigated in the Civil Rights Commission is not included in that 2-year period. So if discrimination, I believe, happens to me today, and I file a charge of discrimination within 6 months with the Ohio Civil Rights Commission, if they take another 6 months to investigate it, then I'm really still going to have the same amount of time I had when I filed the charge, roughly 1.5 years. If for some reason the person has thought about it, not sure what they're going to do, and the 2-year period expires, let's say tomorrow, if I filed the charge today, it's still the 2-year statute of limitations, but while the charge is pending, there's an additional 60 days. So really what that means is after a decision has been made, the person will have 60 days to file a lawsuit. A little bit unlike the Equal Employment Opportunity Commission, when a decision is made and a finding, probable cause or no probable cause is made, the person has 90 days to file a lawsuit in federal court or it's forever barred. The 352 and the state law says that the statute of limitations is never going to be shorter than 2 years. Once they get that right to sue, they have up to what would be a total of 2 years to file the charge, regardless of when they receive a right to sue letter. Next slide. So one of the things in terms of liability, prior to House Bill 352, in addition to suing an employer as an entity or the government as an entity, employee could also sue a supervisor or manager individually, so individual liability. And oftentimes they did all three. They would sue the employer as well as the individual managers or supervisors. That has been changed now so that an employee cannot sue for discrimination a manager or supervisor. However, under, as it says, individual liability will be preserved under sections I and J. They can individually hold someone accountable for retaliation and for anybody who aids and abets of discrimination. So maybe a supervisor who participated in a discriminatory decision to terminate somebody could be held liable. Or retaliation, the person files a charge, or maybe not that formal, they just complain about discrimination, and it can be shown that after that they were fired because they made that complaint. Individual liability can still be attached there. And then finally, public policy claims. Public policy claims for wrongful discharge, even though you hear that term a lot, have always been challenging to bring and succeed on. And what this is saying is that you can't have both. You can't have sue someone under 4112 and under a public policy claim for wrongful discharge. And again, a lot of times attorneys did both as plaintiffs' attorneys. So that, I guess, is helpful for defendants and for companies. The next part of House Bill 352, the next slide, is it codifies an affirmative defense that attorneys can use. Typically, this is used anyway, and it's back to a U.S. Supreme Court decision, or the Ellerth decisions, which basically says a lot of different things. But one of the things that's looked at is, did the employee take advantage or abide by the company's policy for reporting discrimination. And if they didn't, that can be an affirmative defense. Here it talks a little bit about tangible employment actions and actions that are intangible. Without going through all of that, the definition of a tangible action is similar to or the same as the Supreme Court, something like a significant adverse change in job responsibilities. Obviously, terminating somebody is going to be a tangible employment action, demoting someone, failing to promote them, those types of things. And this is for sexual harassment claims only that this defense has been codified. So it's built into the statute. I don't know that it necessarily changes how people plead the cases, but it is some backup. There is some backup now in that it's a part of the 352 statute. Okay, next slide. Also wanted to talk a little bit about some of the cases, the case law in Ohio. I picked 6 cases, tried to pick some recent cases from 2022, as well as cases that involved, all of these involve public employees. Some of them are related to the section we just talked about, 4112. There's a couple in there even for the State Personnel Board of Review. So the first case is Ingram versus Regano. Mary Beth Ingram was someone who worked for a local school or an elementary school, volunteered there. She alleged that what this case was about was that the school superintendent and the assistant superintendent retaliated against her after she reported sexual harassment. This is a case regarding immunity because typically officials, depending on the position, have immunity against these types of things. They pled at the beginning of the case a judgment on the pleadings, arguing they were immune from a lawsuit under Revised Code Chapter 2744. The district court denied their motion for immunity, and this was affirmed by the Sixth Circuit. And what the court says is that Ohio law protects officials from liability and personal injury suits, but it comes with exceptions. For example, it withholds immunity from officials when they act with, quote, with malicious purpose, in bad faith, or in a wanton or reckless manner. So all that means really is that the case could proceed, that they weren't shielded from the case. It wasn't dismissed because they had immunity. It really is going to be something for the jury to decide. The next case is Bowman versus South Vienna. This is a 2021 case, and it involves due process rights for a village police chief. So the village of South Vienna hired Bowman, female auxiliary police officer, in 2017. In July of 2020, they brought her on as a police chief. At that time, the deal was she was supposed to be in a probationary period for 1 year from the date of hire, so really until July of 2021. However, the mayor found and noted that there were many times that she was not performing up to par. And finally, this all kind of blew up in the final incident where she left a loaded shotgun, a computer with the LEADS program on it, and the gas card for the village in her cruiser when she dropped it off to be repaired. So obviously anyone could have access to that. So that was kind of the last straw. It was determined that she did not satisfactorily complete her probationary period, and the city council meeting voted that she would be given the option to resign or be fired. She did neither one. Instead, she left the meeting, she cleaned out her office, she left the building, and didn't really tell the council what she was going to do. So not surprisingly, the council fired her. She appealed to the Clark County Court of Common Pleas, arguing really that she should have been given due process because she served longer than the 6-month probationary period, which is what is required by statute. So this court agreed with her. She ordered her to be reinstated. However, the second district reversed it, said that she had no due process laws under the statute, essentially saying that the statute doesn't say that probation cannot be longer than 6 months. And here the mayor had never said that she completed the probation, so therefore she was essentially still on probation when they terminated her. And as a result, the trial court lacked subject matter jurisdiction to hear her appeal in the first place. Take a sip of water here. The next case is a short one, Gerst v. Ohio Department of Transportation. This was a State Personnel Board of Review case, or at least it started there. And Jessica Gerst was an employee of the ODOT, Ohio Department of Transportation. She thought that she was performing things that she shouldn't be performing according to her job classification. Her duties exceeded the level of her job classification. She requested that the Ohio Department of Administrative Services conduct a job audit. They did, and they determined that she was properly classified. She appealed to the SPBR. A evidentiary hearing was held, and SPBR agreed that no, she was performing the job duties at the level within her classification. She then went to Common Pleas Court, who found the same way, and finally all the way up to the 10th District, who all agreed that her position was properly classified. I think the takeaway from that is if an employee is having an issue or saying that they think they're doing work they shouldn't be doing, for a state employee to request a job audit. And just to make sure that in actuality that they're not doing something beyond the scope of their duties, because if they think that they are, this is the result, even though in the end the decision was upheld. That's a lot of extra time, money, etc. to get there. The next case is Brady v. Youngstown State University. This was another State Personnel Board of Review case, or at least I'm categorizing it that way since it went through SPBR. Brady was a classified employee who worked for State University in the bookstore. In 2016, the university decided, as a lot of universities have, that it was no longer going to run their bookstore because of fiscal and money reasons. They were going to outsource it to Barnes & Noble, and they laid off Brady. Brady, essentially his job was eliminated. Brady appealed that decision, the abolishment of his position, to SPBR. The administrative law judge at SPBR found that, yes, the position that Youngstown State was justified in eliminating Brady's position. Okay, there's a few steps in the SPBR process. So while that decision was awaiting approval by the board, Youngstown State rescinded the abolition of his job and offered reinstatement with back pay. Yay, right? But eventually, Youngstown State laid him off again, this time for fiscal reasons. This time, instead of for fiscal reasons, it was due to lack of work. The bookstore wasn't operated by Youngstown State anymore, didn't have any comparable position, so he was laid off a second time. After the SPBR was notified of this, they dismissed the appeal. And Brady did not appeal the second layoff to SPBR, but he went directly to Common Pleas Court. The Common Pleas Court found that the SPBR dismissing the appeal was not an adjudication, so therefore it's not appealable. There's nothing to appeal. This was affirmed by the 10th District. The lower court held that SPBR's order adopting Youngstown State's rescission of its position abolishment was a ministerial act and not an adjudication subject to appeal pursuant to RC 119.12. We agree. The fifth case I want to talk about is the International Association of Firefighters versus Barbish. This was a 2022 case and really has to do with civil service position, what is considered a vacancy. And sometimes this happens when someone retires and then they're rehired in the same position, or they retire with the intention and with the intention from the city or the state that they're going to be rehired in the same position. So here, the International Association of Firefighters, the local 1536, sued the city of Whitcliffe and the mayor for alleged failures to follow civil service rules because they allowed the chief powers to retire so that he could get his pension and then immediately be rehired. The union's argument was that when he was fired, this created a vacancy, so they didn't have the right to just automatically fill it with the prior fire chief. It should have been handled in accordance with the Ohio Civil Service rules. The trial court granted summary judgment against the union and saying vacancy is not defined in the code. Essentially, it's not subject to any technical definition. It has been held that a vacancy for the purposes of this chapter occurs when a position that has been established and occupied becomes vacant by reason of death, retirement, dismissal, promotion, or other permanent absence of the formal incumbent. So essentially what they were saying, how do you define vacancy if the person is leaving the job with the intention of coming back to the job, being reappointed, something other than those things spelled out and not permanent, then really it's a temporary separation. If it's temporary separation, it doesn't create a vacancy, and therefore there's no need to fill the job under the civil service rules. And then the last case I'm going to talk about, Townsend versus Kettering, really deals with the part of the code that I mentioned, section 4112.02, in terms of retaliation and public employee immunity. Here, the plaintiff, David Townsend, sued the city of Kettering, as well as the fire chief and the assistant fire chief based on race discrimination. He believed that he was passed over for a promotion to fire captain, and the claims against the fire chief and the assistant fire chief were because they allegedly aided and abetted this discrimination. And so one of the issues first was, do they have immunity against this type of lawsuit? The trial court denied immunity, and it was affirmed by the 2nd District. And the reasoning of the court was whether an employee acts in the scope of employment is generally a question of fact to be decided by the jury. So essentially, this isn't something that should be decided at the summary judgment stage. The trial court has concluded genuine issues of material fact exist as to whether they engage in discriminatory conduct, and that a fact finder or jury could find in their favor. And they conclude with, accordingly, under the procedural posture of this case, genuine issues of material fact preclude a conclusion as a matter of law that they're entitled to community. So an issue to be decided. And all of this, by the way, is in addition to the slides, are available in the slides that you can sign on to for part of this presentation. So if you missed any of that, no problem. Probably should have told you that at the beginning. Many other cases, but these were just 6 that I thought involved probably most of the audience in terms of being public employers, county, state employers, or human resources people. So I'm going to kind of switch gears here and talk a little bit about these. Are somewhat 2 different subjects, but not really. One of the things was talking about bullying, the lack of civility, microaggressions, and discrimination laws. So one of the, I guess I would say, buzzwords sometime now is microaggressions. I would get calls from people in our job saying, you know, can I sue the employer because I believe that they're committing microaggressions against me? Which at first was like kind of the soft human resourcey microaggressions type of things, but microaggressions and bullying. But I think those things can lead to certainly problems in the workforce as well as lawsuits. So if we start first with bullying, just the basic definition, seek to harm, intimidate, or coerce someone who's perceived as vulnerable. Bullying is pretty much the same way it was when we were kids in grade school. It's basically, there's the aggressive bully, and this is someone who might scream at their coworkers, threaten them, use other means of intimidation, scream at the supervisor. Sometimes there's a critical bully who makes jokes, gossips, tries to humiliate coworkers or subordinates or managers. There can be a gatekeeper bully who withholds resources to try to manipulate people into doing what they want, or they take credit for others' work, or they ignore coworker. And then there's institutional and departmental bullying, where a company really allows and accepts this. They know that the supervisor's unprofessional, manager screaming and yelling, don't want to deal with it because maybe that person gets good results, or they know that the employee is doing that, but sometimes we don't like confrontation, so we let it go. The things to watch out for, I mean, people, like I said, typically the concept of bullying is something that's not new to us, but some things to see if that's happening, and if the coworkers are avoiding a certain employee, maybe this employee is regularly not invited to parties, lunch, get-togethers, Maybe a manager is constantly checking up on an employee because they don't think their work's up to par. Sometimes maybe it's not. If someone's being ridiculed, that type of thing. And it might be, some of the things that I think you don't say, both for this and the microaggressions as well, deal with it, man up, woman up, put on your big boy pants, that type of thing. Even though it's tempting to do that, and sometimes you feel that way, this could be planting the seed for some future action down the road. The next topic is microaggression. And at first, when I first heard this, I'm like, ooh, microaggressions. But it is a real phenomenon and has a definition. And a microaggression, by definition, is something that's a statement, an action, an incident that's regarded as an instance of indirect, subtle, or unintentional discrimination against members of a marginalized group. So typically being based on race, ethnic minority, it can be female, etc. And I think the key word here is that typically it's unintentional. The person who's doing it doesn't really realize that they're doing that. The tendency is to say, well, it can't say anything anymore. Everybody's easily offended. This is ridiculous. And maybe sometimes it is. However, again, that's not really the way to handle it unless you really want lawsuits and discrimination charges. So some examples of microaggressions might be someone who's a Black student, they're getting praised. Hey, you're really well spoken. You've got a great command of the English language. And that's intended to be probably a compliment, but could be viewed by that person as a microaggression. Someone telling a coworker who said they were gay, hey, you don't even look gay. Or someone pronouncing a person's name wrong. Hey, it's too hard for me to say your name right, so I'm going to call you something else. It might be assuming that an older coworker doesn't know how to use technology. We're not going to give the project to Bob because Bob's old. He doesn't know how to do PowerPoint or whatever case might be. Could be maybe for an Asian, someone of Asian descent, of specifically going to them for help on math problems, and on and on. Those are things that by definition are microaggressions, but also by definition are not necessarily something that you can sue for. So the question is, when can they sue? Why does bullying, lack of civility, microaggressions even matter? And part of that is because sometimes they plant the seed for being able to sue. And I think it goes back to what we talked about at the beginning, the section 4112 of the Ohio Revised Code, and I've had it repeated on the next slide. Maybe it's looking more so focusing on what constitutes discrimination under that code. So if you can do the next slide. One would be retaliation. And actually those are sometimes the most often type of claims that we see. And it's where someone, people call and say, well, I'm being retaliated against because the HR person didn't like that I did A, B, and C. That's not going to be retaliation. Retaliation legally is if someone engages in protected action, which could be filing an official discriminatory complaint, or it could be just saying on their performance appraisal, I think I'm being discriminated against or complaining. And then the employer knows about it, the employer takes a materially adverse action. And of course, causation, you've got to show that the only reason or the main reason the employer took that action is because of the employee engaging in protected activity. So I think in terms of determining when does bullying and microaggressions cross the line, it's really looking at the statute itself. It's an unlawful discriminatory practice with all the usuals because of race, color, religion, sex. If you're treating someone less favorably in the terms, conditions, or privileges of employment or any matter directly or indirectly related to employment. And so typically we look at it as material terms of employment. Someone isn't getting invited to a meeting or didn't get invited to the company picnic. That in and of itself is not going to be an unlawful practice. Or even some of the things that I said previously in terms of what are examples of microaggressions. That's not going to be, probably in most cases, something that is legally actionable. However, those are where the seeds are planted. It still doesn't mean that the issue shouldn't be addressed. It might be talking to the individual who is saying these things. When you get complaints about that and trying to see what is the root cause of that. If someone's turning to people who are of Asian descent because they think they're good in math, that's probably saying that it's based on some type of stereotype. or, women in the old days that were responsible for getting coffee or those types of things. But I think it's really looking at the statute itself in terms of what constitutes a discriminatory practice, and that's how you separate that from bullying and from microaggressions. And I think, the final one I want to talk about is that section I and J of 4112, which is where I talked about the opposition clause and the retaliation clause. And again, for here, it's looking at J in terms of whether this is bullying or microaggressions or that type of thing. What the statute says is it's unlawful to obstruct or prevent any person from complying with this chapter or any order issued under it. So it would be something, for instance, if an investigation was being done and by maybe an internal department and the supervisor knows about it and says, basically, if anybody talks about this, I'm going to make sure you get fired. Or just maybe someone has made a more formal complaint and the Civil Rights Commission or the EEOC wants to talk to that person. They do talk to the person, and then the supervisor or manager is unhappy about that and tries to take some action against them. It's these specific types of things that are going to be unlawful retaliation, as opposed to some of the statements, bullying, microaggressions, and that type of thing. So it's a lot of material to cover in a short period of time. I hope there was some takeaway for everybody from it. And of course, as I mentioned, you can also go to the link on the SPBR website to get the PowerPoints, especially with the cases. So thank you for your attention and enjoy the rest of your day.